Good afternoon, everyone. My name is Sophie Kwasny. I'm the head of the Data Protection Unit of the Council of Europe in France. And it's a great pleasure and honor for me to welcome you today to this event, 2021 Data Protection Day in Africa. It is a great pleasure because it's a day of celebrations for us in the Council of Europe. This Data Protection Day was established already 15 years ago by our Committee of Ministers, raise awareness on the right to data protection. And the date was chosen because it's the date of the opening for signature of a landmark instrument in the field of data protection, our treaty. Global treaty, as some of you now refer to it, our Convention for the Protection of Individuals with regard to the automatic processing of personal data that we know under its short name, Convention 108. And because it is the date of opening for signature of this convention, 28th of January, 1981, today is also the 40th anniversary of the convention, so quite a date to celebrate. And celebrating is an opportunity, of course, to acknowledge what has been done in those 4 decades. And for that, I would first of all like to mention that for us, for the Council of Europe, even if it was always the vision of the convention to have this global relevance, it is an achievement that today we're here with you in Africa, that earlier for me in the night, I was in a similar event held for the Asia Pacific region, that later today in the evening, I'll be in Latin America, and that regulators around the world are actually using the potential of the convention that was drafted 40 years ago, but for which the relevance is just immense and significant today still. Another key achievement, of course, because indeed it is a 40 years old instrument in a time where we did not have those technologies to help us in our work, is that this instrument has been modernized in 2018. It was a long process, but in the end, we delivered a fit for purpose for the digital age instrument and fit for the need of cooperation at international level that you have. This is really one of our pride, and this is also something to celebrate today. If I can give you just a snapshot of what we're doing today, I've already mentioned some of the events, but also to highlight that the committee of the convention, so it's the committee that groups the 55 countries that have acceded to the convention, that are bound by it, including 5 African countries, some of them being represented today on the panel. This committee just adopted guidelines on facial recognition. They are released today. You can find them on our website. This is significant work that has been successfully managed. I can tell you it's not easy to negotiate text at 55 plus observer countries, so a total of 70 countries. I've mentioned our 5 African countries that are parties to the convention, but I also want to mention the observer states because some countries that have not yet acceded are contributing to the work as observers, and it's also the case of some present today. Let me now also refer to one of the news that will be issued today. It's the granting of the Stefano Rodotà Award. Stefano Rodotà was really a defensor and thinker behind the development of the right to data protection. And he was a professor of law, very dynamic in the academic world and wanting to develop the scholar path to data protection. And so we've established this award in his memory and really to stir and give an impetus to scholar work on data protection. And we're very happy that we've had plenty of applications. The winners will be announced today. And this also makes me very proud to have with us the University of Pretoria co-organizing the event, hosting. So before I pass the floor to Frans for his introduction too, Just few housekeeping rules to let you know that the event is being recorded. You will be able to find it on our website later on, and that you have a Q&A option in the system to enable you to interact with the panelists. Our moderators will be managing that. So without further ado, Frans Viljoen, Professor of International Human Rights Law and Director of the Center for Human Rights of the University of Pretoria, you have the floor. Thank you very much.
Thank you so much, Sophie. And once again, from my side, also welcome to all the participants and our panelists. It's really a privilege for the Center for Human Rights here at the University of Pretoria, to be a co-host. And we thank our colleagues at the Council of Europe for their collaboration and for inviting us to be part of this. Allow me to say one or two words about the Center for Human Rights here at the University of Pretoria. Our mandate, our mission is really to look at research and advocacy, capacity building, and education around human rights in Africa. In that regard, we have a number of research units. One of them focuses on expression, freedom of expression, access to information, and digital rights. And Hlengiwe Dube, who will be one of the moderators, is actually the manager of that unit. But more broadly, the center focuses on strengthening the work of the African human rights system, including the African Commission. And we've had a supportive relationship with the Special Rapporteur on freedom of expression and access to information. And clearly the topic of today also extends to and overlaps with that mandate, and I'm sure that there will be a reciprocal engagement. But today's event is about celebrating, on the one hand, 40 years of Convention 108. Congratulations to all involved. But it's more than that. It's also an opportunity for a cross-continental conversation, a conversation from the Council of Europe and Europe and the African Union and African states. It so turns out that the core human rights instrument in Africa, the African Charter on Human and People's Rights, is also celebrating 40 years of existence this year. And I'm sure there is a link in what we discussed today. There will be other opportunities to celebrate. Just to note that. The African Union instrument that is more topical to our discussion is the AU Convention on Cybersecurity and Personal Data Protection. Let's just recall that that was adopted in 2014, many years later, had not yet entered into force because only 8 out of the required 15 states had so far ratified. So perhaps in our critical engagement, in our discussion, there will be also an opportunity to reflect on that convention and to perhaps find inspiration that will take us towards the entry into force of that. So once again, from my side, not to prolong, but to say thank you to everyone involved, welcome, and let us have very excellent and productive discussions. Thank you.
Thank you very much, Frans. So indeed, I will be moving to our two masters of ceremony now. You've already mentioned Hlengiwe, the manager of the unit on expression, information, and digital rights of the center. Hlengiwe Dube. Welcome, Hlengiwe. And we also have with us Pat Walsh, the Executive Director of Privacy Matters. And so they will be the ones now moderating the session. So I leave you the floor.
Thank you, Sophie. Just before I move to the first discussion with the Commissioner from Ghana, I just wanted to briefly bring up this map, which I hope you can all see.
We can see.
I've updated it to reflect a few things. But I think it's really important because Africa is at a momentous crossroads for me. There are now approximately 30 countries that have their own laws. And that's out of 54 countries, but approximately only 16, 17 countries, some would say 19, have data protection authorities. And then just to discuss what Frans referred to, you have the Malibu Convention and you have the SADC and the ECOWAS and other instruments in Africa. And hopefully we can get to discussing how Africa moves to a Pan-African framework and what that might look like because of various pressures within Africa and externally, driving digital agendas, for example, driving trade. So I'm going to stop this now and just introduce Pat Poku, who's the Commissioner, the Data Protection Commissioner for Ghana, who I know well and is one of the respected commissioners in Africa. So Pat, it's over to you.
Bush, my very good friend, and happy anniversary to the Council of Europe for the Convention 108 and now the Convention 108 Plus. We are very glad to have that, and happy Data Protection Day to all my peers on this call. I thank you all for giving us this opportunity to participate in such an important program and discussion for today. It's a very great day for data protection and privacy in Ghana. And Pat, I think your map is very impressive, and although I'm aware of the fact that many African countries have now passed the law, seeing the green on the map just tells us how far we have come from where we were just a few years ago, even 5 years ago. It was all gray, and now Africa is indeed going green and acting this really very relevant law. And for us, it's a big inroad into achieving some status of awareness within the region, which didn't exist in the very recent past. A lot of the work that has happened in Africa is thanks to Council of Europe and its effort and the push and support that it has given to some of us to enable this happening. Most of us on this call will really agree with me that we have had immense support from the Council of Europe, and we really appreciate that. We have a lot of up and coming countries also preparing their bills for Parliament and pushing to establish their commissions. This is all really amazing achievements for us here in Africa. The African Network of Data Protection Commissioners have also made a lot of effort to bring together African data protection supervisory authorities to create a presence of authority in the region that will also support the work. Many are from the Francophone Africa, and the network has charged me with a mandate to organize Anglophone Africa and to enable the establishment of more Anglophone supervisory authorities in Africa. We are making a lot of work, and I'm excited to see Kenya with us today. Kenya is one of the most recent countries that passed the law and now establishing their data protection authority. We have Nigeria, we have Uganda. Some of them are with us today, some are not. The Anglophone group are very actively connected now and discussing how we can pull together and join the network and also work collaboratively with each other to standardize the implementation of our mandates and the requirements for data protection across the region, to liaise with the African Union to ensure that there's consistency of practice around the region, all based on our standardized acceptance of international conventions such as the Convention 108 Plus as a structure to work on. So all of the things that we need to have together, I think, is pulling together gradually, and I'm getting really excited about what's about to happen in Africa. I think there's going to be an explosion of relevance and awareness in Africa, and we are going to begin in this year seeing Africans standing up and asserting themselves and demanding their data protection and privacy rights, and it's going to be an amazing delivery of data protection and privacy requirements here. I'm not sure if you can hear me clearly, but I see Omar on my screen, and I don't hear him. So I hope yeah. Okay. So I'm glad that we are where we are now. Thank you very much. In Ghana today, we are celebrating Data Protection Day with a lot of interventions and discussions on radio and TV promoting data protection at the national level too. Thank you.
Thank you, Pat. Might I just ask a question before we move to Hering? And so in terms of Ghana and the development, the national development of data protection law, we've seen that Africa has a number of regional and Pan-African instruments, such as the Malabo Convention. And then we see increasingly the need to consider the international dimension. Are there any particular developments that we can expect in Ghana in relation to the development of your data protection framework?
Ghana is one of the countries that has ratified the Budapest Convention on cybersecurity and the Malabo Convention on data protection and privacy. We are working, in fact, indeed, yesterday I was discussing with Sophie, working on Ghana ratifying the Convention 108 plus rules. All this is to pull together to align with our act to ensure that Ghana is not just inwardly focused on our local law, but ensuring that we are abreast with the international best practice standards that is being adopted globally to deliver the requirements of data protection and privacy. So that is a lot of work we are focused on.
Okay, thank you, Pat. In relation to the map, I will. It'll be amended in relation to Western Sahara, also, just for those that have an issue with that. So I'm going to hand over to Hering, who's going to introduce Immaculate State from the Commissioner for Kenya. Over to you, Hering.
Very much, Pat. So I've been introduced, just to repeat my name is Hlengiwe Dube. I'm with the Center for Human Rights, managing the digital rights section of the center. So we also want to extend our thanks to our Europe, and it's a pleasure to welcome everyone that is on the call. It is my pleasure now to introduce to you our second speaker, who is the Data Protection Commissioner. She's Ms. Immaculate Kasey. Immaculate, you are in this role. It's a new role, and also the data protection law of Kenya is still pretty new. So we are going to hear from you how you have managed to slide into this role. Somebody has already said that you have hit the ground running. So you are going to appraise us on the situation in Kenya with regards to data protection, and I'm sure that the new law has already been tested with the developments that are taking place. Over to you, Ms. Immaculate, and you have 5 minutes.
Thank you very much. The organizers, that is the University of Pretoria and of course Council of Europe, I truly thank you for the opportunity to, let me bring this closer so that I can speak, for the opportunity to be part of this panel, and I wish my colleagues in the sector a happy Data Protection Day. I'm happy to hear that today the Council of Europe is celebrating 40 years. It's a great pleasure to be part of this. Quickly, just briefing you in terms of a bit of background in as far as data protection in Kenya is concerned. Kenya has had a long journey of spanning of almost 8 years before we could get the first data. But from the first time we had a data protection bill, which was drafted in 2012. And the act comes almost 9 years after the Constitution of Kenya 2010. And the act is hailed as one of the most progressive globally, and it was arrived at after intensive public consultation to be able to accommodate the stakeholders' view, and the principles have been incorporated therein in terms of what the realities of Kenyans are. To enable the effective, because with an act we also need to implement the act through regulations. The Cabinet Secretary for ICT, Joe Musheru, has recently gazetted a task force to develop the regulations. So the task force, which I'm chairing, has a period of 6 months to be able to come up with the regulations. Some of the roles is also to create awareness in as far as the Act is concerned to members of the public, and also come up with the regulations in as far as the implementation of the Act is concerned. So since I came to office, it's now slightly over 2 months. I came into office in November 16th after being gazetted by His Excellency. And in the last 2 months, we have set up our priorities for the next 6 months to 12 months. And the first priority, basically, being a new office, is establishing the internal structures. The second priority is developing and having in place operational framework, including the regulations. And the third priority is creating awareness. Chair of CTN is here. We spoke earlier. We've just been admitted as a country to be members of the Common Trend Network. We appreciate, Patricia, please pass our gratitude to the network, is to be able to build networks. And I'm happy I have peers here who are experiencing data protection. We'll be sharing experiences in as far as your different jurisdictions are concerned. I believe this platform also gives us an opportunity to hear what other countries are doing in as far as data protection is concerned, so that we also begin to build on that resource that is available here. So by and large, that is what we've been doing since the last 2 months, and we are hopeful moving forward we will be able to have further in collaboration. Thank you very much, Ms. Dube, and over to you.
Thank you very much, Madam Patricia, for the intervention, and also that it looks like indeed you hit the ground running, as it has been mentioned by one of the participants. Maybe before we hand over to the next speaker, are there any challenges like that Kenya is facing in terms of the current law in implementing the law, in terms of the institutional framework, or any other developments or any other challenges that you would like to share with us? You are still within the 5 minutes that is allocated to you.
I think the regulations, because the regulatory framework is what we are working on. It might be 2 months, might be too early in the day to talk about implementation and any challenges we faced. For now, it's just getting the regulations. And then we, at some point when we can share in terms of how then that goes. Thank you.
Much for that quick response. It's still early in the day for Kenya, so we still have a bit of time to monitor the developments as you take up the role. I just want to hand over now to Pat.
Thank you, Khenge. Before I move on to the next speaker, though, there is a question in the Q&A for Commissioner Kasait, which is, what is preventing Kenya from acceding to the Malabo Convention, which Franz mentioned in his introduction at the beginning? Thank you, Commissioner. I think you're on mute.
I'm muted.
Oh, there you go. Can hear you.
Yeah, being a new office, I want to underscore that one of my mandates is to actually encourage international collaboration. And first of the task is to actually undertake an assessment of those international conventions. And I believe that's why we are here today, to discuss Convention 108 plus, so that we begin, and I say that's part of our priority, to build on networks. So perhaps we can have this conversation in the times to come, and then I can have a more comprehensive answer. But for now, that is our role. Thank you.
Thank you, Commissioner Kasait. And I'm delighted now to introduce the Privacy Commissioner for Mauritius, Drodesha Madub, who I've met on a number of occasions and also had the great pleasure of working with on the UN Global Pulse Big Data Advisor Group, which is doing good work also. And I think often when I talk about data protection laws and developing data protection authorities and developing data protection laws in Africa. Often Mauritius is also, in addition to others, for those on the call today, one of those models to look at. So, Commissioner Madhuba, I'm looking forward to learning. You have 5 minutes to discuss national development on data protection and in relation to also Convention 108, I guess. Thank you.
Thank you so much, Pat. I'm so glad to be around with all the colleagues and friends today. Happy Data Protection Day. Happy anniversary to the Convention 48. And got 2 more years to go. Let's say 42nd birthday before 2023 for Convention 108 plus. Yes, definitely these last few years have been very innovative and transformative for privacy in Mauritius, because we have revamped our Data Protection Act, which existed since 2004, in January 2018 to align with the principles contained in the EU GDPR and the Convention 108. So the importance of harmonizing, domestic laws with international privacy laws or instruments like Convention 108 greatly facilitates data flows and trade between countries, especially now between African borders, because we are all talking about this adequate level of protection, which compared to EU standards, or now we are developing, let's say, African standards with regard to adequate protection. So in this really, in this digital world, if cross-border data flows are not being facilitated, and they are the lifeblood of international trade, especially during the COVID-19 pandemic, with the sharing of health data across the globe. I'm putting a lot of emphasis on cross-border because I will tell you how Mauritius has actually been very a leader in this field. So the government of Mauritius, through the ratification of Convention 108 plus in September 2020, the first African country to ratify Convention 108 plus, and we believe it is really a universal instrument, and it has to be promoted as an instrument which binds the world, and countries outside the EU, including Africa, they should really go towards ratification of this convention. And my point is also that, even if we talk about an African space, African countries, including the rest of the world, we cannot operate as segregate economic blocks centered around, regional sovereignty, which makes cooperation amongst nations very difficult to expand, because we are talking about a global market, we are talking about global data, we are talking about a global world. So geographical blocks is a good starting point, but data is global and will remain. So it's very important to implement backstops that give assurance that appropriate safeguards to governments without undermining global economic growth. This I would like to share with my African counterparts as part of our philosophy and rationale behind data protection safeguards. So Convention 108 plus is really a strong, flexible, multilateral legal framework which will facilitate the flow of data across borders while providing effective safeguards when personal data is being used. On the same note, Mauritius has also started discussions with the European Union on EU adequacy to be recognized as a safe and adequate country in terms of data protection. Right now, we are in the process of appointing a consultant an international consultant who will make a feasibility study and assessment of our data protection laws in Mauritius and submit the report to the EU for their consideration for adequacy. And Mauritius has signed and ratified the Malabo Convention on 14th of March 2018, and one of the precursors also of the convention. And we have been very active in participating in trade agreements which incorporate all the legally sound conditions, including data privacy, to allow cross-border data flows to happen. We have allowed data to flow by default with the appropriate safeguards to create regulatory certainty for businesses. Examples of trade agreements like TISA, multilateral economic partnership agreement, negotiations with other countries. Otherwise, to conclude, on a domestic note, the ratification of Convention 108 Plus has triggered organizations in Mauritius to really be privacy friendly in processing of personal data. So thank you for now. I hope this has been quite clear. If you have questions, Pat, you're welcome. Thank you so much.
Thank you, Dwadesha. I do have a few, as you might expect, it being me. But I think one of the benefits of Convention 108 Plus is that it's now been 25 years that I've been working in this space. And I've been working with Convention 108 since all of that time. The UK's law 1984 incorporated it. One of the things of 108 Plus is that it gives the ability, it imposes obligations on data protection authorities to work together on sharing information on enforcement, but it also gives individuals in those countries where 108 Plus has been ratified, has been implemented into law, to complain and raise an issue with the data protection authority in that other country. So a person in Mauritius could complain, for example, to the commissioner in the UK. Once the UK gets around to signing 108 Plus, you got there before them. So how do you feel that will work in practice? Because for me, in a globally connected world, and I listened to you last week on another session, one of the things about Convention 108 Plus is that it provides this protection across borders. It reaches out and protects people as their data flows across borders. How do you see that working?
Yes, definitely. I'm very passionate and looking forward that Convention 108 really creates that environment where, we will be able to multilaterally cooperate with each other across frontiers and across borders. And I guess, yes, it's going to work in that way because, as you know, it's binding on our countries, and we have to implement the safeguards provided in the convention. So in this aspect, I'm sure that cooperation is going to be meaningful and efficient, because if we have Convention 108 as our support, this is going to be a reality.
Thank you, Commissioner Maduba. I have a few questions for the others, so I'll wait. There's been a slight change in the order of speakers. So the Commissioner from Morocco will be appearing last, and now we will move to Sizwe Snail, who's with the Commissioner of the Information Regulator in South Africa. Welcome, Sizwe. I think a lot of people on the call might be looking forward to see how the South African law is going to be fully implemented and given effect, and people's rights given life in South Africa. So over to you. You have 5 minutes on national, and the next session will be on the international dimension. Thank you.
Thank you very much, Pat. Thank you, the organizers of this conference, the Council of Europe, as well as my beloved alma mater, the University of Pretoria. I've been given an opportunity here basically to talk about what we call in South Africa the countdown to the grace period. As one may know, we have had the POPIA since 2013 in terms of it being a piece of legislation, and the information regulator then subsequently, the office of it was then established in 2016, late that year. What then happened was, in the period of about 3 years, the regulator was busy with teething. The regulator was busy setting up shop, and it was very nice to actually inform delegates at an international conference last year around this time at the CPTB to say that in the second quarter of the 2020, that the president would be approached to bring the remaining sections of POPIA into law. And that then happened. The president acceded, and on the 1st of July, a proclamation was made that for a period of 12 months, there shall be a grace period in which the remaining sections of POPIA are now enforceable. However, the grace period is put in place there so that there are no punishments against anyone who has not complied. It's basically a period, as I aptly put it, for people to get their house in order. It's not a period for people to remain non-compliant. It's not a period for you to go to your legal practitioner and your legal practitioner tells you, yeah, it's just a grace period. You haven't done anything. No, it's a period to look at your organization. It's a period to look at the POPIA and the prescript of it and to see how one can develop a culture of data protection. Just to put it into the legal context of international frameworks, I'm one of those people who doesn't actually like to refer to international pieces or conventions as Bibles. I like to refer to international conventions as international best practice. And I think Convention 108 and 108 Plus are beautiful examples of that. I mean, if we look at our constitution, in South Africa, we are one of the few countries in Africa that actually has a right to privacy. So our data protection law, as much as it is emulated and has taken bits and pieces from Europe and the rest of the world, we still go off from the basis of the right to privacy. And this right to privacy has now been further developed in our POPIA. And what is most interesting is that when our courts or any tribunal or any semi-judicial forum or administrative forum such as the regulator pronounces on our law, our constitution requires us to look at international law. In other words, it doesn't say you may, like foreign law, in other words, the law of another jurisdiction. In terms of international law, it says you must look at it. So for me, the Convention 108 Plus and 108 has been really a beautiful tool in assisting, in particular since we're in Africa now, African states to look at their legal reform and to draft legislation that is in line with international best practice, my emphasis. That being, it's very important to not isolate the African continent. And, maybe in closing of what I wanted to say, I'm one of the proponents of an African privacy norm. In other words, I don't believe
I think it's frozen this way.
But can we proceed to the next? Seems like we've lost Sizwe.
I was just checking to see whether it was my laptop, but okay, I had a few questions, but of course, Linga, you go next and introduce the Commissioner from Morocco and move to that section. And then we have a number of questions in the Q&A for everybody, which we will get to, so don't worry.
So thank you so much to Sizwe, although his presentation was cut. I think we are going to go back to him so that he finishes the point that he was trying to make. But now we are going to move over to our speaker from Morocco, Mr. Omar Segrushni. I don't know whether I'm pronouncing it well. Omar is the Data Protection and Access to Information Commissioner in Morocco, and he also has another role with regards to the conversation that we are having today. Omar is the Secretary General of the African Network of Data Protection Authorities. So we'll hear from you, Mr. Omar, about the developments that are taking place on privacy and data protection in Morocco, and also maybe also enlighten us on developments around the African Network of Data Protection Authorities. Over to you, sir.
Many thanks. I am very happy to be with you all today. I am here as a Moroccan GPA. I think that about the African network, we have here Mrs. Patricia Poku, who is a member of the bureau. She is vice president of the network. And as you know, the permanent secretariat is an administrative tool at the disposal of the bureau. So I prefer, and I think that she did, Patricia could speak about the African network. What I am speaking about today is our experience in Morocco. As you know, the law was established in since 2010, the law at 9, and the commission, the authority, was established since 10 years now, 10 years and two more. And what we can say, what is our feedback, and what is the interaction with Convention 108, for example, is that we are trying to work concretely on all the territories of the country. I am very happy that Pat will correct the map, but we are working from the north of Morocco to the Mauritania frontier to deploy problematics of data protection. After 10 years, our experience shows to us that we should move from the logic of granular treatment. As you know, we have treatments of different concerns: human resource management, video surveillance, temperature monitoring, and all this. And our observation is that we can have a company or an administration which notify some of these treatment, but not all the treatment they should to have. So we are now installing a logic of ecosystem compliance, and we think that this kind of work to establish a logic of ecosystem compliance will be very efficient, and it can help us to be more efficient, more compliant. So with this, we can move from the priori control, the prior check, to a politic of post-checking, and it will help us to develop the accountability of data processor and of data controller, and it will be more concrete together. It's all what I can say in briefly. We have 10 years of work experience. and during these 10 years, we can observe different points to enforce, and we do all this under the inspiration of the Convention 108 and all the international standards. Thank you.
Thank you very much, Commissioner. At least we've heard the experience from Morocco. I don't know, Pat, can we ask Commissioner Patricia to briefly say something about the data protection authorities in Africa, the network?
Okay, since Omar has pushed this on to me, I'll say something briefly about that. So the established data protection countries that have established data protection authorities have come together as a network of data protection commissioners for the region. It is not all the countries with data protection laws that have joined the network, and we are working actively in the network to increase the membership of this network. The pandemic last year stalled the progression of election of new leadership for the network, and we are hoping that sometime this year we will do a remote conference, General Assembly, that will enable the selection of new leadership for the network and to strategize on how we manage the network going forward for the rest of 2021 and beyond. Thank you.
So Pat, sorry for
Hi there.
Hi, Sezwe. I think it's raining.
Yes, it's terrible. We've got a thunderstorm here, and for the first time, my router actually went out. But thanks God, I have a cell phone.
Okay, yes. Well, thank you. There was something I wanted to ask you.
Yes, please.
No, you go on. Sorry, you go on. Well, there's something I wanted to ask you, and actually it applies to all of you data protection authorities. Because when I look at data protection laws, there are 144 data protection laws around the world and approximately 219 countries. But the one thing that every single country has, of course, because where they have mobile phone networks and where they have fixed line telecommunications, is that they have telecom laws. And those telecom laws may provide provisions for the protection of the privacy and confidentiality of communications and data. But often data protection laws don't reflect that. And often you may or may not have a regulator responsible for that. Do you think, in your experience from South Africa and across Africa, that data protection laws are sufficient to address online privacy, particularly in relation to communications metadata, and of course the fact that governments are always under pressure to do something about national security? So do you think natural data protection laws are sufficient to address online privacy, particularly in relation to communications?
Well, considering that our POPIA was born in the digital age, in other words, it wasn't born in the pre-digital age like in some of the European states. One can appreciate that I think our POPIA did have the electronic communications and telecommunications market in mind when it was drafted. I mean, I recall even during the drafting process, they went through vigorous stakeholder engagement across all different sectors. And I think that is why even our POPIA in particular has the provision with codes of conduct in order to allow certain sectors to comply with our law in a functional equivalent manner. But with that having been said, I think the POPIA is now 7 years old. I think so much has happened across the globe. I don't think the POPIA can withstand the test of international best practice any longer. And I think it will definitely require some re-looking. I mean, if the whole world is re-looking at privacy online and the United Nations are even dealing with it and coming up with solutions, then definitely I do think that the online communications as a whole do need to be revisited, and the protection of data subjects needs to be heightened, especially vulnerable groups such as children and elderly people. That's my view.
Thank you, Sizwe. If it's okay, there's a question in the Q&A for Commissioner Sagrushny, which is why is Morocco's application for adequacy from the European Commission taking so long to be approved? Commissioner Sagrushny, over to you if you are able to answer that one or feel you wish to.
Many thanks, Pat. I can have two kinds of answers. First to joke, and the second more serious. The first to joke, we could be happy to have the adequacy. You can ask to European Commission, because the adequacy is a process of adequation, as its name says, and it's the approval was from the European Commission. To be more serious, as you know, there was the process of approval of the GDPR, the European Regulation legislation, and this was approved in 2016 to be deployed in 2018. So when Morocco asked for the adequacy at the beginning of 2010, the discussion about the GDPR was ongoing, and the European Commission said to us that we should wait for the final process of the GDPR. And after 2018, we could re-engage the process, and the priority was for the countries which was already considered as adequate for Europe, as Argentina and other countries. And now what I can say that we are discussing with the European Commission since a few months, and we are working to prepare our application. It is not a question of only of documentation, is also a question of a process of laws of all things, and it is one reason why we are now working also for a new law. We are working for preparing a new law in Morocco to prepare and to be able to facilitate this education.
Thank you, Commissioner Sagrushny. That was an excellent reply, but might I just come back very briefly in that you said you are reviewing your existing law. You have acceded to Convention 108. In Convention 108 plus, the European Commission and the GDPR itself, recital 105 of the GDPR, provides a basis for the European Commission to consider accession to 108 plus in their decisions on adequacy. So in relation to Morocco's review of its current law, is that, will that include accession to 108 plus? Because if I might, just joking slightly, in that one of the challenges for adequacy from the European Commission is that with so many countries in the world, I will be pushing up daisies perhaps before it gets to have considered 25 countries adequate, given the process that it currently takes. So in your review of your law, is that considering accession to 108 plus, which gives you a means via recital 105 for that to be considered in adequacy decisions by the European Commission?
I'm not sure to have understood all what you said, but I can say that we have two targets, the 108 plus and the adequacy. And for the 108 plus, we are working to be sure that all consideration of the 108 plus will be in the future law.
Thank you, Commissioner. Twenge, sorry. Twenge, did you want to move on?
Yes, I'm here.
Okay.
So I think we've heard from the experiences of all our speakers, the country experiences, what is happening in Kenya, what is happening in Morocco, South Africa, Ghana, and also I think we've just been briefly told about the network of data protection authorities, because I think there was a question in the Q&A section here where someone was asking if there is collaboration between the data protection authorities. Yes, indeed there's a network, as we have been told by Patricia, and they also regularly hold activities. Yes, so I think we can move over, looking at the time, I think we can move on to our next session, and I think Pat, you introduce the first speaker.
Yes, so it's back to the Commissioner for Ghana, Pat Baku. This is about international cooperation, international transfers, Commissioner. What are your thoughts on, when I look through the Q&As that are there today, which you've all got access to, there's a common theme, and which is that that Africa, are there plans in Africa to deal with the cross-border flows of data? Then are there plans to deal with the cross-border flows of data out of Africa? So between African nations and then from African nations globally. So what are your thoughts on that from a Ghanaian perspective, from a Ghanaian law perspective?
We have a challenge in Africa where some of our laws predates the firm establishment of definitions for cross-border, what the expectation of what the global standards should be for cross-border exchange of data, because some of our laws are quite early, especially the French side. But the recent catalyst of inter-trade arrangements, the cross-African trade needs that is led by the African Union, has triggered the interministerial decision to pull together and harmonize some rules for Africa. And so the recent AU-led project called the PRIDA project has attempted to pull together to standardize the rules or the principles by which Africa cross-border data flows should be. That was one of the principles that was shared for all African countries to comply with. If I cite the Ghana law, for example, it's quite gray in there exactly what the state's policies, the Ghana Data Protection Act, wants to say about cross-border processing of personal data. There is a kind of gray statement about comply with the rules that of the country whose data you're processing, etc. But no specific strong rule in our act. So the PRIDA project became very relevant and important to me as the leader of my my country's supervisory authority, because it was beginning to set a standard for the region that we could use to implement our local policy on what the rules should be for cross-border processing. And I think we're not alone in here, where there are other African countries. Many of our laws require some sort of amendments to firm up and to be clear about what we mean that principle should be. So there's a lot of work that needs to happen. But other areas of work for state-level policymakers are pushing for some standardization to happen, and we hope that this year or in very recent future that there will be a firm standardization of the rule that we need to adhere to ensure that there's a one standard that we're trying to deliver cross-border data flows from, because currently it's quite all over the place, if you ask me.
Thank you, Commissioner. I think for me, one of the things that I see happening in Africa, it's a real hive of activity at the moment in terms of intense pressures that are driven by digital agenda and digital economy agendas, whether that is Kenya's own digital blueprint, for example, whether it's the African Union digital agenda, but also we have the African Continental Free Trade Area as well. So to what degree are African regulators, data protection authorities coming together to have one voice, a consistent, harmonized view on what these various policy instruments and free trade agreements should contain in relation to creating opportunities within Africa whilst responsibly using data and protecting fundamental rights and freedoms?
We've recently completed the PRIDA project, harmonizing the rules. So we now have a set of principles, including the one for cross-border flows, agreed at the African Union level. What we expect, or I would, in my opinion, expect African Union to do now is not to leave that harmonized rules setting. We now need to push for the application of the harmonized rules in the absence of one Africa data protection rule that we can all comply with, such as what we have in Europe with the GDPR. We now have at least that set of harmonized rules that we have worked on. We have 5 case study countries for each area of Africa, Central, North, East, West, and all that. And we agreed on what the harmonized rules should be. Now it's on the African Union to push for the state level, the political level acceptance of those rules, in order for us, the supervisory authorities in each state, to adapt those rules into our implementation of the policy requirement. That is what remains, and I'm hoping strongly that the African Union will not stall on that and push for that agenda to be accepted at the AU level.
Thank you, Commissioner. Wenge, over to you.
Much for opening up the second and last session of our conversation today. I'm going to go back to our speaker from Kenya, Immaculate Kasaid, and I'm aware that you are still new into the role. But our second segment now looks at let's talk about the convention itself and the situation in Kenya, and what you think are the advantages that the convention is likely to bring to the situation in Kenya, looking at, we have recently adopted a data protection law and all these other developments that are taking place, and also generally, how could the convention contribute to relationships between African countries, and how does it relate to other regional frameworks on data protection? And also, I think you can also respond to issues around cross-border flows that have also been referred to by the speakers in the question and answer session in relation to Africa in general, and also specifically for the Kenyan experience.
Okay. Thank you, Ms. Dube. I will try my lower voice. Like you said, I may not speak as fluently as Patricia, who has mastered the skill of data protection. I will try. Thank you I will focus on the 3 parts of the question you've asked, the second part, and basically what the advantages are of Convention 108 plus. And from the Office of Data Protection Commissioner of Kenya, and if we were to contextualize this to the Kenya Data Protection Act, it was enacted in 2019. So we have had the advantage of having a law that is enacted after the GDPR, that is 1. And 2, therefore, we've benefited from the world best practices. So that's the advantage that Kenya has in terms of the regulatory framework. So in that case, one of the core mandates of this office is to promote international cooperation on data protection. What that means, when it comes to the issue of Convention 108 plus, it is the role of this office to make sure we are working towards looking at it, assessing it, and making the necessary recommendation for the government in as far as ascending to the law, to that framework. 2, the law, the Data Protection Act does not restrict transfer of data outside the boundaries of Kenya, which is a strategic issue. I know that is one of the concerns under the 108 plus, Convention 108 plus. However, even as we allowed cross-border transfer of data, the Act is very clear that the different institutions must demonstrate to the Office of the Data Protection Commissioner that they have put in place the necessary safeguards to ensure that the data is safe. And the only exception to this is issues around national security or strategic issues. So the office is supposed to come up with the necessary guidelines in as far as this is concerned. And I did mention earlier that we're in the process of coming up with the regulations. And this is one of the aspects that we'll be addressing. In addition to that, when it comes to the connection between the Convention 108 plus, is the transfer of cross-border transfer of data. It's expected that the data subject is supposed to give consent. We appreciate that data is fluid, and therefore we expect that even though I'll emphasize the fact that it's fluid, we expect that data will move from one country to another. So it's important for all institutions to put in place the necessary safeguard. Going to, if you look at the case of Shrim in terms of the relationship between Europe and GDPR, I want to say from a strategic perspective of Kenya, we are keen to, if in the event when we are aware that the European Union only has 13 countries that have ascended to what we are calling adequate decisions. We know that is they've also allowed certain countries to only assent to issues around contractual obligation and clauses. So that is in as far as post-stream case is concerned. However, from a country perspective as Kenya, we would want to approach the issue with the Convention of 108 plus from a strategic perspective, so that if we have a framework, if we are able to have a common agreement in as far as the European Council is concerned, it makes it easier for businesses in Kenya, instead of them having a one-to-one agreement with every business coming to the Council of Europe to look and vet and see whether they are conforming to the standards. As an institution, if you're able to enter into that agreement, it becomes very easy for businesses in Kenya to be able to enter into subsequent agreements. So for us, we see it as a strategic issue in terms of pushing for that for that collaboration, and also the issues around Convention 108 plus. It's in public interest and it's also in economic interest of this country. Finally, when we look at the Convention 108 plus in relation to African countries and ourselves, I want to say that, Patricia has put it very well, that we do not have a common framework, whether it is at the African Union, whether it is the East Africa, whether it is at the East Africa level, whether it is what we call the Northern Bloc corridor, the Northern Corridor countries. We don't have a uniform. Yet, like said by my earlier speaker, it's a strategic issue. So I see the comments coming through Q&A in the chats why Africa doesn't have a common framework in terms of data privacy. It is something that we can push for at the political level. With that, it will give Africa what we would call a leapfrog in terms of the economy and addressing this, what we've been referring to as the Africa's single digital economy in terms of implementation. And African single digit market, in terms of implementation. Two, as Kenya, we see ourselves strategically placed as a Silicon Savannah. So it will also give us an opportunity to have more innovators come into the country and be able to create even more jobs in as far as our youth are concerned, and to create more opportunities for this country. So, and most importantly, in Africa, we have a population of up to 1 billion people. So with a common regulatory framework as a continent, it gives Africa a strategic positioning so that when we look inside Africa first before we look outside, because it means all our laws in as far as we have a common framework in as like GDPR, Europe has GDPR or the Convention 108, so that we have one place to look at as Africa before we then look outside. I think that is what I would like to say. There was one more question that had been asked earlier. I think I must have noted it earlier on whether Kenya. There was a question around privacy and privacy laws vis-a-vis telecalls and all. And I want to perhaps share that in as far as Kenya is concerned, we have complied. In fact, when the Data Protection Act came into effect, it expects the Kenya Information and Communication Act of 1998 to actually comply with the Data Protection Act in terms of the principles therein, putting in place safeguards. So the advantage, like I said, is coming after the GDPR gives us an advantage in as far as compliance of the other privacy laws are concerned. Thank you very much.
Just briefly, there is a comment from Moses there before you hand over to the next speaker. Moses is saying that I'm sure it will apply to other speakers as well, but he's saying, can you please comment on the fact that Convention 108 Plus does not provide for the establishment of a dedicated judicial body competent to resolve disputes arising from its application. Do you have any comment on that?
Can I go first? And
yes,
this
please.
Is from I think the data protection has embraced a lot on, or at least speaking from a perspective, issues around promoting self-regulations. It takes cognizance of the fact that when you're dealing with privacy, data privacy, a lot also has to do with e-commerce. And going by experience, more and more businesses would rather have what we call alternative dispute resolution mechanism than going into a litigious process that actually then creates acrimony. So I would imagine in terms of principle, that could be the reasoning around that. I could be wrong, but that is my take in as far as why there might not be a dedicated court framework, judicial framework in as far as dealing with issues around data privacy is concerned. And number two, the office of the data commissioner in Kenya in particular is quasi-judicial in nature. And it's expected to come up with institutional and legal framework. And part of the institutional and legal framework includes how the complaints are filed all the way to how the disputes are resolved. So in that sense, you can also look at this office as a quasi-judicial. Thank you.
Thank you very much. Over to you, Pat.
Thank you, Klwengele. Before we move on, I think I'd like to give Sophie Kwasny from the Council of Europe the opportunity to respond to that question also from Moses. Sophie?
I'm here. Thank you. Yes, indeed, to highlight that one of the novelties of Convention 108 Plus that was absolutely not foreseen in the 40 years old text is the necessary establishment of a data protection authority. This only came in 2001 with an additional protocol. So I think it's a very important part of the enforcement system, of course, and that's why we're happy to have so many regulators with us today. And then you have a specific provision in the convention that does foresee that there is a need to have remedies available in case of violation of the provisions of the convention. So then it's for the national law to see how to manage that, but the provision is there in Article 12. Thank you.
Thank you, Sophie. It's time to move to Commissioner Madoub from Mauritius. Commissioner Madoub, recently on the matter of international flows of personal data, you raised a concern about the very strict nature of the GDPR and the complications that is creating, particularly post-Schrems 2. And as a data protection officer, I have sympathy. You commented on the need to view this globally because of the nature of services, rather than looking at it as geographic blocks. So perhaps you could comment further along those lines, particularly as we heard from Commissioner Kasait saying, well, Africa, actually we need African laws for Africans, but is there a danger then that you end up, just as Europe was before the GDPR, with these challenges in cross-border and still being challenged in addressing matters internationally, given that 108 Plus gives you an opportunity to work internationally on these things?
Yes,
Thank
definitely.
You.
I appreciate your comment, and I do understand the concerns behind having, less data localization requirements and more cross-border data flows facilitated. I do understand the problems of national sovereignty and all the issues that we've been having. But if we look at the perspective that, let's say, for example, we have an African space and we have a European space, we have Asia Pacific space for global for economic considerations, which are very proper and appropriate. But the synergy that is required between these four geographical blocks, if we have restrictive, I'm not talking about sound data localization requirements and sound principles with regard to cross-border transfers, with regard to essential guarantees. They're all here. We know post-Schrems, they're all here. European data is being safeguarded. EU GDPR is here. Extraterritoriality is being applied. We appreciate all that. But now with all these beautiful safeguards in place, and if we look at the position, let's say, of Africa, which is already, as you know, weaker continent in terms of our perspective right now as compared to other blocks. So we have to appreciate the differences that actually are in play. And we also have to make certain, room for, consideration. If we, harmonize principles in a way that put everybody in the same basket, in Africa, this is not the case. We all have our differences, our specificities. But if we look at business global, means we have standards where everywhere in the world it's being applied, then these principles come like, really a futuristic application, and people would want to apply these principles. But if we say we have African principles, for example, let's say the Malabo Convention is here, but we know, very frankly speaking, that the Malabo Convention is not up to date. We have Convention 108 Plus who has come. We have EU GDPR who has come as well. So the Malabo Convention is again struggling. And despite having a little ratification right now, tomorrow it might be called upon to be revisited. Again, like what happened to the directive, the EU directive of 1995. By the time, there's so many things that has happened with the GDPR. So again, we can foresee that with the Malabo Convention again, that might be the same scenario happening. So what do we do? I mean, do we have time to say, okay, Africa, let's harmonize? Harmonization is a long-term process, and the African Union has already embarked on this process. We know that. But how much time it will take for Africa to really have these principles that will, promote African business across Africa is a question I don't think anybody has the answer yet. So what do? Do we actually go for such principles which are taking so much time? Or do we go like our colleagues also have pointed out for agreements that are more practical in nature, trade agreements going faster? And these agreements, Pat, actually, they are incorporating international data protection principles. And it's not even Africa, it's not even Asia, it's not even European. So they are just putting in these principles that have to be here for the agreement to work in a way that brings the results that it is asking for. So in this way, we actually, what are we promoting? We are promoting principles which is traveling from each country to the other. And there's no such thing as geographical blocks here. So this is what I'm trying to say is we should make the right equilibrium and try to make these principles which are already here working and also incorporate certain pragmatic principles that have to be here to make things work faster. And this is what I'm aiming at. And Mauritius actually, like also in our DPA, we have made data transfers by default a possibility. There's no longer this requirement for authorization from the commissioner. Yes, but there are other safeguards that they have to implement before transfer is possible. And we have this power to see whether this is the case. So we have facilitated in our DPA itself cross-border data flows happening across the world. But we know that, for example, EU hasn't done that in the way that we have done it because the equivalence of countries, the adequacy of countries is a very important concern. It's an important concern for us as well. But I guess there's at some point in time, we will have to make the right balance between whether we want our businesses to flourish the way we want them, or we want to apply certain restrictive requirements which will actually hamper business. So in that perspective, in that economic perspective, I'm not saying the human rights perspective is not being taken into consideration. Yes, they are, but definitely the balance is key. Thank you, Pat.
Thank you, Commissioner Madhu. We'll move to Sizwe again. I think, Sizwe, building on what Commissioner Madhu said, when I look at laws in Africa, just as anywhere else, if I look at the 144 laws around the world, what's common is that you have to meet certain conditions to transfer personal data overseas, one of which is consent, and consent, I think, is particularly problematic in the international transfer scene. But one, of course, is that regulators can consider other countries adequate. Do you believe that that is workable? That a regulator like yourself, or even Commissioner Sukrishni, or even Commissioner Madhu, or Commissioner Poku, do you believe you have the resources? Is that a realistic thing? So how do you deal with international flows of data? Does it need something like an international legally binding instrument?
Well, I'm going to refer to our POPIA. Our POPIA, I think, is clear on that. It talks about exchanging personal information with organizations or persons in other countries that either have an adequate data protection system, or alternatively, there should be corporate agreements in place between the responsible party, or data controller, as you would call it, and the other side. So what I think is important is, and I'm going to go back to what I said earlier on, I think we must look at international best practice. I think that is the word that we should start adopting when it comes to data protection. I don't think there is any data protection law of any country that is better than another. And I'll tell you why. If data protection laws were so ascertainable and not as so fluid as they are, then it wouldn't have resulted in so many legislative changes in the last 15 years in Europe. I mean, we were still looking at the European directives, and whilst we were still busy with that, came the GDPR, and so it's a constantly changing environment. And this is not an environment that is changing because of individuals, but it's because of the type of industrial level that we are and the intercommunication of companies and organizations. So, once again, I'm really a big supporter of international best practice, and our law prescribes certain things on adequacy. As to whether our regulator at this stage, with the limited capacity, can do adequacy assessments, and that is a question for another day. But I think it would be ideal if one could have a internationally accepted set of principles, which is what is happening in my mind, for instance, and one should try to give effect to these principles. And as new principles come, your right to be forgotten, your portability, your privacy to design, as these things are developed, what is good for the guys in Europe is good for us in Africa as well. We just need to evolve, and we need to implement these particular legal concepts into our laws. Thank you, Pat.
Thank you, Sizwe. Riley, are you going to introduce the last session with Commissioner Sukreshni?
Yes, Commissioner Omar from Morocco, we are coming back to you on the issues around the convention, and also comment just on the cross-border flows that other speakers have also been commenting on, and issues around harmonization and the adequacy of our regulations in Africa, and also just bring in the Moroccan perspective. Also, best specifically going on to what our program says, the guide on our program is saying that you should at least also tell us about the advantages of the convention in Morocco, and also what does the convention mean in the post-REMS era for relationships between the EU and African countries, and also looking at the convention and how does it contribute to relationships between African countries, and how does it relate to other regional frameworks on data protection. So I'm just following the program, and also just asking you to address these issues, but also the much talked about cross-border flows in Africa, in light of the recent developments as well in the African Free Trade Area. I think it's a very important conversation to continuously have. Over to you, Mr. Omar.
Many thanks, very much. As you know, we are working with our colleagues in Africa. We are working on the PRIDA project, the project which Patricia noted before. In this project, I have the pleasure with my colleague in Nigeria to chair the data protection work group. And the problematic you are discussing since the beginning of this session is very important. The cross-border and how to harmonize the cross-borders flow. or rules to manage the cross borders. My opinion as a GPA, a Moroccan GPA, and you know the geography is particular for Morocco. As it usually said, Morocco is a tree with roots in Africa and leaves in Europe. So we are obliged to work in a global vision and with a global vision. Our opinion is that the importance is to ensure the protection of the circulation of data flows. And we cannot say, and I agree with Rudesha, we cannot say that the data flow will stop at the Africa frontier. We should work with a global view at the worldwide, with the worldwide perspective. Donc, so the approach for us, it is difficult to have a territorial block perspective. We should have a universal point of view. But we should be sure that there is the good balance is respected between Africa and our other partners in the other region in the world. So my conclusion for this point is that it is necessary to have a data flow perspective and not a stock perspective. We cannot protect data in keeping them in our pockets. We should accept that the problematic for the business, but also for the others, for the cultural approach, not only for the economic approach, also for the cultural approach, the data should circulate and should be protected and should be shared and should be protected in this sharing process. So the cross-border problematic for us is very, very important. It is very, very important to harmonize it in Africa, but thinking to harmonize it in Africa to facilitate the global harmonization. Thanks.
Thank you. Thank you, Commissioner Sakrushny. I think we are desperately running out of time. So I think it would be good to, I'll call on Franz and Sophie if they wish to say a few words and close the event. As always, you could go on forever having these conversations. I'd like at least another 2 hours.
I don't know if Franz is joining us or not for say a word to thank everyone. I think it's been really a great session, fascinating insights. As Pat just said, I would have again continued for hours. I want to thank the panelists for their engagement and really interesting takes on questions that are problematic indeed. It was a pleasure to celebrate this 40th anniversary with old friends, meet new friends, and in particular, Commissioner Kassaït, just to let you know that you are very welcome to join the work of the committee, not commit to ratifying the convention, but just come attend the meetings and see what it's about. This I think would enable you to make your own assessment of the value of the convention. So once again, I want to thank all of you. It's been a great pleasure to have you on this occasion. Happy Data Protection Day and happy 40th anniversary to the convention. I applaud all of you. Thank you very much. Goodbye.
Thank you.
Goodbye. Thank you, everyone.
Thank you. Goodbye.